will
give a letter to the advocate calculating the permanent tenure.
very well.
And can that
Can be done. Even to that extent, it is
quantification is not there.
Lakshya, but that
Because it got for by demand.
by demand by draft. By your lordship.
This will be without prejudice to
Without prejudice, because they will then press in the court that this is the only way we suffered. We suffered. I am obliged, you all.
Interesting. By the learned. The commercial court at Rajasthan is not 24 Parganas. In Miss Art Form number 24 of 2024. Miss Art Form. The petitioner agreed by the direction of the learned court to deposit the sum of 40, 40, 80, 40, 03, 0.1, 40, 18, 40, power 40. For this interest component, as per the calculation certified by the chartered accountants of the current advocate of the petitioner submits that the same calculation by the chartered accountant is not part of the award. Section 19 of the Micro, Small and Medium Enterprises Development Act. Micro, Small and Medium. Permit the petitioner to file an application for setting aside the award. The statutory mandate be that the challenge to the award shall not be entertained by any court unless the petitioner deposited, would not be entertained by the court unless the petitioner deposited 75% of the amount in terms of the award. According to the petitioner, also the arbitral tribunal recognized the liability to pay interest at 3 times, perform interest at 3 times the rate of the RBI. The interest component was not quantified. Thus, according to the petitioner, although our noted liability to pay interest, the amount of interest did not form part of the award. The amount of interest calculation was a subsequent event, and the chartered accountant of the opposing party filed the calculation before the learned court. Then the application under section 19 was filed. Based on the following decisions of this court in support of such conviction.
Page 17.
Page 17, Babu sir.
In support of the contention that the interest component is not quantified by the tribunal. Tribunal fails in its statutory, and as such, the person agreed by the same award is not liable to pay because it 75% will be liable to deposit 75% of the principal amount calculated. Because one candidate for the opposing party submits that the award includes the interest component. The awarded sum has to be calculation of both the principal and the interest. Section 16 employs buyer pay interest at the rate of 3 times. They compound interest at 3 times the RBI rate. And the MSME Act statute, recalculation statute specifically enacted for protection of small and medium scale industry or for protection of medium scale. Partners in construction should be given the provisions of section 16. Meaning thereby, legislative intent was to ensure that the seller should be duly protected and continue with the business despite tendency of an dispute for the competent owner. According to the learned advocate, the seller is entitled to withdraw the deposit or continuity of business, irrespective of the final adjudication vehicle. That is why compound interest at the rate of 3% was allowed, and the statute also allows the petitioner, as an opposite party, to withdraw the amount for continuation of the business. That's it. If the interest component is not deposited along with if the calculation is made, only the deposit is to be made solely on the principal awarded. The same shall render the provision of section 16. It relies on the decision of this court in the matter of the support conception back. What should be the appointed date? What should be the monthly rests? And how the amount was to be calculated upon taking into account those activities. Unfortunately, the same decision was rendered in a situation in an execution case where the final adjudication was made regard to the amount payable in the execution of the order. The case in this case, the case before this court is slightly different. The question is, if the interest component is not quantified by the arbitral tribunal in the award, whether the petitioner should be forced to deposit 75% of the same amount calculated by a chartered accountant at a later stage after the publication of the award. Then such calculation was not a part of it. What is it? It has to be enforced like the quantity is not a part of the, it is not a typical amount. The chartered accountant to assist the court while the calculation as selected by the tribunal. Hence, in my view, at this stage, it would be improper to rely solely on the chartered accountant's calculation to fix a deposit of 75%. The interest calculation can be decided at the final hearing of the application section. The liability of the petitioner to pay compound interest at 3% of the at 3% over and above the RBI rate.
So three times the RBI rate.
Pay compound interest at 3 times the
Bank rate.
Bank rate of Lordship, pursuant to the previous order. Lordship,
But if liability of a borrower to pay social so is a
Part of statutory provision.
calculation. And we all in my private
Lordship, may I, Lordship, pursuant to Lordship's order, already 8 crore was deposited. Lordship, Lordship.
the liability of the buyer to pay the interest is a part of the award as per the provision of section 16. But as the quantum has not been specified,
Adjudication. Adjudication may be used.
not specified. At this stage, to hold that the chartered accountant's calculation and final would be unjust. 11 code relies solely on the application of the chartered. Under such circumstances, that the sum of rupees 1 crore, further sum of rupees 1 crore over and above the 6 crores, it was already deposited.
And same was withdrawn.
Deposited before the learned court. Where the
Lordship, again, preferably if in cash, because I think
demand draft. Demand draft.
Lordship, there was, I modified the order last time.
Cash to demand draft only.
There was a problem with the withdrawal of demand draft because their infrastructure is not there. Lordship would find that.
Cash.
Cash.
But then it was modified by your Lordship only. That cash deposit was.
No, cash was there, then modified.
Then modified.
Demand draft.
Yes.
That is the modification.
Cash to be
So, ma'am, cash, your lordship. Demand draft, your ladyship.
Cash Lordship. Then demand draft.
amount for which is included because already deposited by the commissioner and withdrawn by the party can be deposited before the learned commercial clerk. Other commercial court at Jagannath. Within 2 weeks,
Within 4 weeks. Go.
3 weeks by demand draft.
In favor of the opposite party.
No. In bank only, there would be a condition for the withdrawals.
In the same manner as
Yes, as was done.
That is best.
That is best.
and the party shall be allowed to withdraw the same amount.
Not only one indulgence, the Lordship's observations should not stand in.
Next,
Without prejudice.
please pass the prejudice the rights and contentions of the parties and without prejudice to the merits of the application pending
No.
before commercial court. The learned commercial court will decide what it should in accordance with law. With the deposit of the further amount of rupees 1 crore, the application shall be appealed filed by the petitioner shall be regularized and the learned judge will dispose of the appeals in accordance with law.
And deeply oblige you.
Lordship, may I take back my book, Lordship?
Deeply oblige.
What should You should tell the arbitrators.
Actually, this is a regular practice of this tribunal. There are 5, 7 judgments. We are
Same.
all the same. There is a mechanical judgment.
That is not it, but Lordship, but there were circumstances how it's mechanically the arbitrator, the council passed.
Then they will do sit there through maths.
Lordship,
Come to their own.
Lordship, it is the council's fault which I. Lordship,
No problem.
Lordship,
No, my lord.
Very well.
Lordship.
Very well.
They will have to.
They
I
will-
mean, we are all suffering from the council's fault of not canceling.
Yes.
Item number 9.
Lord 9, my application, my lord.
No, I am for the opposition
For-
party. Number 3.
I may grieve by a order passed whereby now application under order 6 rule 17 has been allowed, my lord. If I am allowed to take your lordship to the order impugn for once, which is at page 15 of the application. The urgency is the matter is fixed before the trial court on 1st of February, my lord. My lord, the situation or circumstance under which this application was taken out, it was taken out at a stage when the cross-examination of the defendant's witness is on the verge of completion.